Good morning, Your Honors. May it please the Court, Daniel London from London Fisher LLP for the appellee, Tokyo Marine and Nishido Fire Insurance Company of Japan. Your Honors, it's our position that the District Court correctly looked to the insuring clause of the various policies in order to determine the level of policy obligation adopted by the insurers and understand that before moving on to the insurance conditions of the policies. This is required under California law, not only under the Olympic case, which is a California Court of Appeals case, 126 Calap 3rd 593, but under the more recent Carmel case, 126 Calap 4th 502. As the Court said in Carmel, looking to the other insurance condition of a policy before determining the level of policy obligation by reference to the insuring clause of a policy would entail, quote, reading the policy backwards. And that's what the appellants have asked us to do here, and that's what the District Court refused to do. Therefore, dismissal of Mitsui's equitable contribution claim was entirely correct because an excess insurer owes no duty of contribution to a primary insurer. We had a chart in our reply briefs underlying this appeal. It appears at ER 72 of the record. And I think it's helpful in showing in a graphic manner the way in which this insurance program was designed to work. In short, and this is also reflected in the Tanaka Declaration, Tokyo Marine issued a policy to the Japanese parent company, Kyocera, which policy was designed to provide coverage in the event that any subsidiary failed to provide coverage for itself or failed to procure the correct coverage for itself. The policy was, by design, an excess or an umbrella policy. By contrast, each of the subsidiaries of Kyocera, of which there are many, more than a dozen listed just in the identified additional insured section of the Tokyo Marine policy, each of those subsidiaries was required and expected to purchase their own insurance to insure against their own risks. Kyocera Documents America did that by purchasing the Mitsui policies. And the design of this program was so that the Mitsui policies would respond to the risks, and the Tokyo Marine policy would be available in the event that there was some lack of coverage or some very large claim that exhausted the coverage. That's perfectly reasonable and makes perfect sense. Indeed, it would be absurd for KDA to have spent its own money purchasing insurance from Mitsui if it was able to get identical coverage from its parent corporation without paying for it. With respect to
Counselor, would you help us out with endorsement number 8? That's
Sure.
At least as I look at it, one of the key issues in this case. And you've heard counsel's interpretation of it. I'd like to hear yours.
Sure. So endorsement number 8 takes a standard form commercial general liability insurance policy and modifies it so that it will achieve the purposes that the insured and the insurer sought to achieve here. If we flip to endorsement number 8, which appears at ER 201 of the record, we see that it says, if damages from a particular occurrence is not covered by the, quote, scheduled insurance, and that scheduled insurance is described later in the endorsement at ER 204.
Stop there for a moment. You heard counsel saying there was no scheduled insurance.
Well, the scheduled insurance is identified in the policy as a...
In other words, you dispute what your opposing counsel is saying?
The scheduled insurance is identified in the policy as a policy of insurance that was written to provide coverage during the period October 30, 2009 to October 30, 2010. That policy of insurance was in effect with respect to certain Malaysian risks for Kyocera, which is an international company. That policy of insurance does
Answered
not
that.
apply in this instance.
I don't think you answered my question.
The scheduled,
Dispute what your opposing counsel has told us in open court.
the scheduled insurance would not have applied in any event to
The
this.
question was there scheduled insurance, and if so, what was it?
Yes, Your Honor, the scheduled insurance is identified at ER 204 of the policy.
And it was in effect
was
at the time?
It was not in effect at the time. According to the,
That make a difference?
it doesn't, Your Honor, because we have a provision which provides if damage from a particular occurrence is not covered by the scheduled insurance, we will pay those sums that the insured becomes legally obligated to pay as damages because of bodily injury or property damage included within the product's liability, or rather product's completed operations hazard, to which this insurance implies in excess of the greater of the retained limit, which is 0 in this case, or the sum of an amount collectible by other insurance and the amount of any deductible and self-insured amount of insurance. So conceding that the scheduled insurance does not apply because it was not in effect, we then move on to the second step, which is to determine whether the loss is in excess of the larger of the retained limit, 0, or the sum of the amount collectible by other insurance. In this instance, the other insurance is the Mitsui policies.
The other and the scheduled are not the same thing in your
Correct.
argument?
And they're defined in the policy to be different things. Furthermore, this policy does contain its own other insurance condition at ER 189. And so in order to adopt Mitsui's argument, we would not only have to ignore the express language of endorsement 8, but we would have to read the other insurance condition at ER 189 of the policy out of the policy entirely. We would have to determine that the modification to the insuring clause and the other insurance condition are surplusage. And under basic principles of contract law, we normally would not do so.
Let me ask you about the, Japan does not appear to recognize bad faith, and accordingly, the effect of enforcing the forum selection clause is that Mitsui would not be able to bring its subrogated bad faith claim against Tokyo. Is that correct?
Oh, Your Honor, actually, the district court found that Japan does recognize, or at least found that Mitsui's expert had, the expert affidavit had indicated that Japan does recognize, quote, good faith. In the event that they recognize good faith, presumably they recognize the
I'm asking you
converse.
about the law. Does Japan recognize bad faith?
Your Honor, I don't know whether under Japanese law there could be a cause of action for bad faith. It's not relevant, frankly, to the enforcement of the forum selection clause in an international agreement. The fact that the causes of action recognized in a foreign country are not identical to the causes of action recognized in the United States is not dispositive of the question.
Well, how do you distinguish Doe 1 versus AOL, in which we invalidated a forum selection clause?
Your Honor, Doe 1 has not been, was not a case that was raised in any of the underlying briefings, as far as I'm aware. But
does that matter if it's raised or not, if it's a question that we have about a case that may apply?
certainly does not, Your Honor.
I think you should respond to the question, in other words.
Yes. So I can't distinguish Doe 1 because I'm not familiar with it. However, I will say that under Bremen, which is a U.S. Supreme Court case, we are required to allow the enforcement of international forum selection clauses in international agreements. In fact, there are several cases, including Lockton, which have found that Tokyo Marine is, Japan is an adequate alternative forum for litigation where required by agreement.
Well, counsel, you heard again the colloquy with your opposing counsel, and they stand in the shoes, he says, of Kyocera America as subrogee, and therefore Kyocera's interests have to be taken into account in terms of how we approach the forum selection clause. What's your response?
Well, my response to that is that Kyocera is an additional insured under the Tokyo Marine Agreement. They're not a stranger to this contract, and therefore under Bremen or under this court's decision in Minetti-Farrow, they would be required to, because they're part of the same transaction, participate in the forum selection clause. Although we've not appealed from the district court's decision with respect to the forum selection clause, we would argue that because none of these claims would exist but for the Tokyo Marine policy, and none of these claims can be proved but for an interpretation of the Tokyo Marine policies, all of these claims should have been dismissed for improper venue. But certainly, any claim which is derivative of the contract must be dismissed for improper venue, and that's what the district court found.
But of course, California law applies, and we do have now the invocation by a California plaintiff that if this is going to be subject to Japanese law, the California rights are being deprived. So what's your response?
Well, Your Honor, federal law would apply to the enforcement of a forum selection clause in an international agreement. Bremen discusses those principles of comity that would require us at the federal level to defer to the courts of another sovereign. But in any event, the California public policy argument that plaintiffs referred to is really not all that strong. As the court alluded to, we have...
Well, in other words, you're conceding that it is an element in this, in the resolution of this issue?
I suppose it is an element that ought to be considered, but it is not an element that would be dispositive. We have a New Jersey corporation, Mitsui, which is seeking to enforce seeking to recover for its own benefit monies from a Japanese corporation. The only reason that the Japanese corporation, Tokyo Marine, has any obligation whatsoever is a Japanese contract between it and a Japanese company. In those instances, and I should add that the KDA, the additional insured, has been fully reimbursed, has no loss. In that instance, there's really no substantial public policy for California to enforce here. And finally, if I may, I wanted to address the issue of waiver. Plaintiff's unilateral decision to file an amended complaint following dismissal of its derivative claims for improper venue waived their right to appeal from the first amended complaint. Under the Forsyth rule, although...
Counsel, wasn't the Forsyth case overruled in our en banc decision in Lacey versus Maricopa County?
Your Honor, the Forsyth rule was limited in the Lacey decision, but this instance does not fit the exception recognized in Lacey because there was no instruction to the plaintiffs that they amend their complaint or withdraw their claims. Rather, I would say that this situation is more like the situation that was addressed in the unreported decision that a member of this panel participated on in LeBarry, 509 Fed Appendix 595. But I wouldn't say that Lacey overruled the Forsyth rule in all circumstances.
Anything further, counsel?
No, thank you. Thank you for the opportunity to appear here.
The case just argued will be submitted for decision, and the court will hear argument next in Irvine District.